about Janelle's age. On learning of Janelle's age, lifeguard advised Sing Lee that a rule for the use of slides is that a parent or guardian must wait for the child in the pool at the bottom of the slide to render any assistance if necessary. Right? So, in other words, the child must be accompanied by the parent. Janelle enjoyed a few runs. Right? On one occasion, when Sing Lee was helping Janelle at the foot of the pool, another child hurtled down the slide only seconds after the other child's foot made contact with Sing Lee's left eye, caused a rupture of the cornea. So this is where the problem starts. Alright? So you can see here, they went to the public swimming pool. Sing Lee was hurt by another child. Right? He was taken to hospital. Damage was not reparable. Right? Severe loss of vision. He has got expenses. Right? And then his argument is this: the pools failed to adequately supervise the use of the slide by children, and therefore he suffered injury. Now, when the question class tells you this, the rights in thought, please do not discuss contract at all. Don't waste time. We know a contract was formed when he brought the child to the pool. So class, contractual issues become quite irrelevant here. Right? So let's check this out first. First, we are going to ask or discuss negligence. So the first thing that you must bear in mind is that there must be a duty of care. So where do you start with that? Right, so here, what you will say is there is a duty of care owed by the pool. Right, have you taken down class the question? Are you able to take a snapshot of the question? Okay, bring it up. Okay, hold on. That's good. Okay, that's the best. Okay. So first question in last year's or last semester's paper, right, is a question on negligence. You can see how important that is to RMIT. So class, it's very likely one question on negligence, one question on contract law. Right, whichever part is going to be, yeah? Yeah? Right, now, let's look at the question. Now, class, first of all, you must establish, I've got to use the balance here. Right? I'll try to put it down. Maybe I'll make it bigger. And I'll go through line by line. Alright, let's look at this class. Now here, the first thing class you must see the entry to the slides section, you was asked about the scenario. So here you notice one thing. Right? Let's put it down class. First of all, you are doing this question, you will define negligence. Right? Your issue is, can he sue? Right? Define negligence. The issue is, can Sing Lee sue the pool for negligence? Because they fail to supervise, right, the ongoings in the pool. The first thing class you must establish here is a duty of care. Then you talk about factual foreseeability, number one. So class, before you can do that, please quote the Spandac case. Right? There must be factual foreseeability. So remember what I told you last week, class, if you're dealing with factual foreseeability, always say it's factually foreseeable that the pool, if you don't supervise, somebody will be injured. So this is how you put it, right? Foreseeable, right, that if there is no supervision, someone might be injured. So factual foreseeability clause is satisfied as long as you can show on a very broad basis that some injury is likely if there is no solution. Very easy to go on with this. Then class next, proximity. What's the relationship class? Basically, you have a service provider and you have a customer. Class relationship here. The pool provides a service. Alright? Sengli is a customer together with his daughter. Satisfied. You can use class Donahue and Stevenson here if you want to. In support. Next question. Is there any policy are you opening up the floodgates? Answer is no, right? No floodgates. Litigation. Right? In other words, no indefinite or unlimited claims will arise. Right, so class, this is the first segment about duty. So basically you are employing all the three components by saying there is factual foreseeability. You are saying that, well, it's factually possible someone will get injured, there's no supervision. Number two, there is proximity because Sengli is a user or customer of the pool, if you will. Right? Then there is no policy here that's relevant because just by allowing him to claim, you're not going to open the floodgates. There will be no unlimited claims. Right, now this portion class, next we scroll down a bit. Let's look at the breach portion. Okay, so I'm done with this. So first duty, second. Let's scroll down a bit. Okay, this is where the breach occurs. So we talk about breach here. So class, here we discuss the breach of duty. Hold on. Right? So at this juncture, we are looking at breach of duty. This is dependent on a standard. Okay, a standard of care is required. And here, the pool has fallen short of standards. So pool right? A reasonable pool, a reasonable pool management will ensure reasonable standards of supervision. This they have failed to do. So we know level of skill is poor. Level of skill. This one is not satisfied. Likelihood and seriousness of injury, high chance. Cost of prevention, low. They just have to put a lifeguard there. Alright? Lifeguard. So class, basically it's low cost versus high risk. So preventive measures should be taken. Okay, that satisfies breach of duty. So you go through the four factors essentially. The pool has fallen short of standards, they don't have anyone to supervise, anybody can come and do what they want in the pool. Because without without this full supervision, what happens if one adult with his child goes down the slide? Say, oh, my child is scared, so I also will go along on the slide. Nobody will bother, right? Because there's no one to supervise. The pool has fallen short of standards. There's no one to bother what's going on. I said, leave it to you. Leave it to the parent to take care. It doesn't seem right. Right, this next segment class, next paragraph talks about the resulting damage. Okay? So here we have the resulting damage to discuss. Right? What happens here? But for test, satisfied. Right? Undoubtedly, class, if not for the incident, you're going to suffer loss of eyesight. Right? Then you discuss remoteness. Injury is reasonably foreseeable as a consequence of the breach, not removed. So we know that, the injury class sustained here is something which you can foresee. It's not something, out of the ordinary. Right? Someone might be injured in the pool. That's always foreseeable. Right? Okay. Class, you can quote the various cases. I haven't put down cases here because it gets longer and longer. Right? So please put the relevant cases. Now, suppose, class, I tell you something more in this question. Give it some thought. Suppose I say, Saint Lee has already a pre-existing eye condition, medical condition. If I say that, would your answer be different? I say, Saint Lee has a pre-existing eye condition. And this injury class made things worse. Or he got the injury first, but because of his existing condition, he became blind. Then you have the eggshell skull rule. So please watch out for that. Alright? Okay, if pre-existing medical condition worsens injury, eggshell skull rule. No defense. So please watch out, class. In this question, but in some questions in the exam, they actually raise this issue. Right? Okay. Right. Next question. Here, class, there is no issue of vicarious liability because the injury was not caused by an employee. So no vicarious liability here. So we go straight to remedies. Right? So let's go on to the next page. Right? Let's ask ourselves first. Any defenses first? Is there any defense that you can think of? Right? Well, assumption of risk not relevant. I mean, you cannot say, oh, people who go to the pool take on the risk of being blinded. How can it be? I go to the pool to swim. Okay? You can't say that. Okay, so assumption is not relevant. Class, is it possible that it could have been contributory negligence? Maybe, yeah. Possible, class? If yes, it affects the quantum of damages that Saint Lee will get. So class, we don't know how he was telling, or maybe he put his eye there and his snow near the slide there and waited there, class, and some other person came and fell on his eye. I mean, it's possible. You don't keep a reasonable distance from the slide, which you should. A normal person will do that. Okay, so you get so close to a slide, of course you will get injured. Alright, so this one you can argue about it. The last bit. Remedy class will be damages. And that's your answer. So you must make sure you do not miss any steps. If you miss a step, class, it will cost you marks. Okay? So avoid that, please. Okay? Okay, now, this is the first question in class, last sem. We are done. Yes?
Regarding the egg-shell skull
Rule.
you say there's no defense.
Yes.
No defense meaning
You can't raise that. Even if you raise that, the judge will say you take the victim as you find him. It's just unfortunate that this victim has an existing medical condition. Okay, so class, you're supposed to say that. I'm just tell the examiner, I know this area of law. Right? So if you have a victim with a pre-existing medical condition, just tell the examiner the pre-existing medical condition will not help the defendant. Okay, just tell them, right? Next question, class. Okay. What is this about? Let me see again. Let me try to make it a bit smaller. Okay. Now, class, question 2, I don't think this kind of question is going to come out in the exam, quite honestly, but this time at least. But I'll just show you what the question is. Because it's too short for this 15 marks, and I don't think, class, you will get this in the exam. So I'm going to skip discussion on this one, but I'll show you the question first and I'll tell you what the answer is. This is 15 marks, class, because last sem the layout was different, format was different, so you can see this. Actually, class is a real case. What is this area of law? Anyone? What's the area of law, class? This one is? Volunteers? Anyone? It's a real case, class. Real case.
I think I'll be right. Cause of prevention.
Frustration? No, not frustration. Very good. That's the one. So, class, this is illegality. Class, this one is illegal contracts. I'll just put a short note before we go through this. Because it's not going to come out. Right? Let's not waste time.
No, bro, I just told you what to say.
Illegality.
Okay. So, class, area of law is illegal contracts, contract, void and formation, illegality, because contrary to the Road Traffic Act, to traffic laws.
可是他讲他不要go through他这些 answer， 他讲可以出来。
This one very minor area. If you can look at your slides, you go back to I think it's lecture 6. I think I'm not too sure. Have a look at it. Illegality. This is what's called contract void and formation, right? And it is not enforceable. So the guy's claim, class, is not enforceable here very clearly, right? So this one, not a major area, is not going to come, right? So let's not waste time. This is a real case, class, and this person was actually charged with a criminal offense as well, right? Okay, please, let's move on to the next segment. Are we done? Okay, let's go on to something more likely, right? The next one. This one class is a likely question.
Likely.
Right. So class, a bit more likely in this one. Now when you look at the question class, you must know the area of law. Now when you have your exam paper before you class, please reserve 45 minutes for each of the 20-mark questions and half an hour for the MCQ at the most. I don't think you need half an hour, but never mind. So 45 minutes of your time should be writing time for the 2 questions, 45 times 2, 2 long essay questions. Right, which area of law is this question about? Which area of law is the question about? Anyone? Which area of law is this? So look at the parties in class. Sumit, and then she is financing her husband's business. Alright, Sumit's the wife. She's financing, using the money to finance a loan to her husband's struggling business, right, which employed her husband. So class, the bank in a way has a conflict of interest because they're also, the banker for the owner of the business. Manager of the bank was aware the business could not be saved. Right? He knew that she was planning to loan but did not tell her anything about it. After a few months, the business fails. What area of law is this? Now, there are a number of possibilities here, class. The first one here, you will notice, is the possible undue influence. Now here, when you discuss undue influence, class, basically you're looking at the position of the husband and wife. Right? Husband here and wife. Now there's no presumption here. The law does not presume that one party is the weaker or the wife. No presumption. But then if you look at the wife here, assume that wife places confidence and trust in her husband. And if you go and take a step further and say, husband manages, right, the financial affairs of the family. Because if you say this, then there could be undue influence, a third category class. Oops, sorry. Right? So if you say this, then class, there could be undue influence, third category, not actual. So it could be presumed undue influence. So it may well be that she's relying on her husband's advice, and he's the one managing the family, generally speaking, because right, she's a cleaner, so she's relying on her husband's business, and so on. Then you need to discuss undue influence here. So here comes the bank, also adding, bank is aware of her plans. The bank keeps quiet, class. And here you might add by saying the because the bank keeps quiet, they have what is called constructive knowledge. They might know, a class, that the wife is trusting the husband. She has reposed trust and confidence in him, and in fact the trust seems to be misplaced. Right? So here they keep quiet. Right? So bank at fault here. The guarantee, right? Okay, mortgage. The mortgage might be unenforceable. Plus, I can say it's voidable. Right? Now, there's one single problem. Class, we just postpone that problem for a while. Hold on a moment. So we say it might be unenforceable. Now, there's one more thing that you can discuss. What is the one more thing? Apart from undue influence, what normally comes with undue influence? The topic. What's the next topic that might become relevant here? Anyone? You could discuss unconscionability as well. Right? So please discuss the next topic as well, unconscionability. Right? So it's a very unequal or unfair bargain. So they call this class, they call it manifest inequality in bargaining strength. Right? Bank was aware of situation, right, but kept quiet. Right? So you can quote the Amarios case, and then you have to, of course, class, question here is whether Sumit, right, is she a person of special disability? Class is something which you must discuss. Does she have a special disability? What's her educational qualification, class? Let's go back. A cleaner. Some business knowledge. That's not good. So class, look at it. For example, not very literate, low education. Class age, I don't know. Right? We don't know her age here. We don't know whether she's ill. All these class question marks. We don't know. So assuming there's a combination class, she has got, for example, poor education skills, age, she's old, she's very blind, her husband, illness is there, then you can argue special disability. Right? Arguable. So, if you look at it, class, the mortgage should be set aside. But there is one major problem. What is the major problem in this question? So general rule, when you have undue influence, when you have unconscionability, mortgages cannot be enforced. What is the problem here? Read the question again. Anyone? What's the problem? Huh? What's the problem that you can see? This is the problem, class. Against the advice of a legal advisor. She went to the lawyer and sought advice. So, class, this is the problem, right? So she had sought independent legal advice. But there is a problem here. She sought independent legal advice, but decided to act against it. Bank may be in better position
先 next time list that
than
应该是吧？
in the Amadio
哎，
case.
是不是啊？好像是没有，是 ENG。
Because this is a major difference. So in Amadio's case, they did not seek legal advice. But here, she sought the legal advice and yet decided to act against it. This is her problem. Okay. And final question, class. Is there any misrepresentation by the bank? So these are side issues, class, which was just on the base for a moment. Any misrep? By the bank? Because the bank kept silent. Huh?
That's right.
No. Can she say, I did not know, class, what I signed? Right? Non-S factum. Not a defense. Answer, conclusion. Mortgage is enforceable. That will be your answer. Right? So here you realize that it's slightly different from norm. They twist it slightly by saying, oh, she got independent legal advice, but then she decided to act against the advice. Right, so class, that ties up this question. There's just one more question I want to show you, and then we can take a break because then we finish the paper. Right? Last question. Stretch yourself a bit today, yeah, please. Yeah? Oh, finished? Are we done?